Oh, greetings, everyone. Good afternoon. I'm Marcy Einhorn. I am a New York attorney and a mediator, and I want to welcome you all to ADR in Guardianship Proceedings. What does that look like? Along with my colleagues, Sabrina Morrissey, Deb Rosenthal, and Carolyn Reinach Wolf, who are three very experienced elder law, trust and estates attorneys, very familiar with guardianship proceedings. So today we're going to be talking about dispute resolution in general and specifically how it applies to guardianship proceedings. And to augment your understanding, we're going to describe what guardianship proceedings actually are. And I'm trying to here we go. I'm going to move you through my PowerPoint. So in general, what is dispute resolution? So in 2019, the New York courts issued a mandate that all disputes coming through the New York courts had to have alternative dispute resolution modalities available for resolution, in addition to having access to traditional litigation resources of the courts. And as a result, the courts now recognize arbitration, mediation, collaborative law, neutral evaluation, restorative justice, conferencing, and special masters as resources for alternative dispute resolution to help expedite resolution of any and all types of cases. But unfortunately, guardianship has not really been the beneficiary of any officially sanctioned alternative dispute resolution modality. So what my colleagues are going to be discussing today is what a guardianship looks like, what's involved, and what types of alternative dispute resolutions might be appropriate in different fact patterns, different factual settings. And to start us off, I'm going to turn it over to Sabrina to begin to explain what an Article 81 guardianship is.
Okay, thank you, Marcy. I don't see the PowerPoint. Do you have it on?
It's up, yes. And
it's okay, that's fine. So Article 81 is Article 81 of the mental hygiene law. So that's the statute in New York that governs adult guardianships. Most of them are brought through proceedings in Supreme Court. However, they can also be brought in surrogates court, but there are fewer proceedings in surrogates court for adult guardianships. Most of them happen in the Supreme Court. An adult guardianship takes place when there are issues such as Alzheimer's disease, severe medical conditions that render the person incapable of taking care of their own affairs. There could be psychiatric issues that result in the person not recognizing that they have a problem. There could be issues where the person has not done, and you'll hear us talk about this as a potential for resolution, but has not done advanced directives. So the person did not do a healthcare proxy or a living will. And let's say they have a traumatic brain injury, and after that point, they can't do it. And if there is no one who has any authority to act for that person or certain authority to act, that's when a guardianship would be brought and would be appropriate. So Article 81 covers the proceeding. It tells you how to bring it. It tells you what the burden of proof is. It tells you the various court appointees that might be appointed to assist the court. Among these would be a court evaluator whose job is to look at the petition, interview people. They can look at financials and also medical information with permission from the court if that is a part, if that needs to be discussed. And they put together a report and present that to the court. The court will have a hearing. The timeline is 28 days unless there's good cause shown. Good cause could be a medical problem with the alleged incapacitated person, which makes them unavailable. It could be family members in another country who can't be here. It could be the court schedule, although that is less of a factor. It tends to be something related to the parties. But the court will have a hearing as soon as possible. They will have witnesses. The person, the alleged incapacitated person, if they object, or in situations where the person has extensive resources that need to be protected, the court will appoint counsel. So that person will have their own attorney appointed by the court. They will also, in some circumstances, the court, and I'll talk about different types of guardians in a minute, but the court can appoint a special guardian if there's a situation where the person has, let's say there's a theft or somebody's taking money, or the court needs to stop something that's happening very quickly, they can appoint a special guardian. Once the petition is brought and filed, the court may also appoint a temporary guardian in the same similar circumstances. So let's say, and this happens a lot, the person has Alzheimer's and they haven't paid their maintenance for 6 months, and they're at risk of being either evicted or they're being taken into court. If there's an emergent need, the court can appoint a temporary guardian, and that person can act immediately. As with any guardian, they act only with the powers given to them by the court. Sometimes the temporary guardian has very limited powers. It could be just 2 or 3 things that need to happen quickly, or they could have extensive powers if the court finds that there are a lot of issues that need to be dealt with before the hearing.
I'm going to interrupt just briefly, Sabrina, to let everyone know that the text of Article 81 should be in the chat. All the handouts are in the chat, and especially for attorneys who are attending and concerned about CLE credit, there will be a code at the end of the presentation for you to submit for CLE credit. And whenever you're ready, Sabrina, I'm going to switch to the slide about Anita's story. You let me know.
Okay, I'm almost there. So one topic that we have on the slide is after a guardian is appointed, what happens? I'm not going to go into specifics because you're going to hear that as we go through the rest of the presentation. For example, Deborah's going to talk about responsibilities of a guardian. I'm going to talk about resolving issues in a guardian, but in a guardianship. Suffice it to say that once a guardian is appointed, the guardian acts with the authority of the court issues an order, and the guardian acts in accordance with that order and also the provisions that are set out for the guardian in Article 81. Okay, so next we'll talk about Anita. Anita is our fictitious character, but she's a New Yorker who has a lot of issues, and these issues are the types of things that we see every day that come up in guardianships. She's not very old. She's 55 years old. She lives in a co-op apartment left to her by her mother. The building has allowed her to continue to live there, even though she never changed the ownership to herself. Her father died. She has no siblings, no children, and no spouse. This is a common demographic in New York guardianships. A lot of cases are brought for people who do not have family members. She inherited money from her mother, which she has not really invested. She has it in savings and checking. So you can imagine that she's not earning a lot of money on her money, which she could do. She has a sporadic work history. She's very bright. She did graduate from college. However, due to a history of psychiatric issues, including diagnoses of schizophrenia and borderline personality, she has not been able to work. She takes periodically medication, but she has not been taking it recently. And as a result, over the past few months, she became increasingly upset with her neighbors and the building staff. She has resorted to cursing at them in the hallway, slamming her doors. They suspect she's a hoarder, and they have experienced smells emanating from her apartment. Again, not an uncommon situation in New York City. She's current with her maintenance, but she doesn't always pay it on time, and sometimes she pays 2 or 3 months at a time. what we have is the building management. So they would have, these people would reach out to Deborah or me or Carolyn with this situation and say, we're concerned about our resident. The neighbors are concerned about this resident. What can we do? And this is why we picked Anita, because if we can't resolve her issues, they are the kind that would go to end up in front of a guardianship judge. However, we try to resolve these issues beforehand. And even if she does end up in guardianship court, we want to talk to you about the way that her issues would be resolved. I will say that she has a friend that he lives out of town and she doesn't see him very much, although she does talk to him. She recently had a complaint, a criminal complaint, also not uncommon, filed against her by owner of a local store where she got into an argument and threw some merchandise on the floor. So again, building management consulted with the attorneys and they want to know whether a guardianship is warranted for her or whether there's some other options that they can pursue. And so at this point, I'm going to turn it over to
Carolyn?
Carolyn. Yeah.
Yep. I'm going to pause for a minute because Don, in the small screen, I also see you're running the PowerPoint separately from the larger screen. I'm not sure if there's a technical problem, but I'm going to continue and turn this over to Carolyn to discuss the possible means to avoiding a guardianship.
Hi, everybody, and thank you for joining us. Some possible means to avoid a guardianship is reaching out to community resource centers, private mediators, law school mediation clinics. Sometimes we make referrals to adult protective services to come in and attempt to address some of the issues that ultimately may lead to a guardianship, but sometimes can be resolved prior to that. As Sabrina mentioned, executing an advance directive, a healthcare proxy, a power of attorney, making your prior wishes known, certainly can aid in avoiding guardianships. But other times they really don't go far enough, and we need more expansive powers in order to suit the needs of a particular client who may come to us. We can offer to apply for assertive community treatment teams, ACT teams, who would come in and assist those people with mental health treatment, education, getting benefits, and so on. Sometimes there are others we can engage, social workers, care managers, therapists, all in an attempt to unite the family, bring them together, as opposed to the alternative of guardianship, which ultimately can become an adversarial proceeding. Mediating issues before guardianship include conflicts with neighbors. Sometimes we can step in and a mediator can bring everyone together in order to resolve those issues. Very common where people live in a communal setting. So that oftentimes if you put everybody in a room together, as you might do in a law practice, we can address some of their concerns and their issues. Sometimes there's family and friends who are refusing to help, and bringing them all together can often lead to some resolution. In my world, in my mental health law practice, we are faced with a lack of insight into having a mental illness and non-compliance with treatment. And so oftentimes mediation can help to make it clear to the individual and families the need for medication treatment, how to go about doing that, how to satisfy everyone's concerns in that area. And sometimes needing to mediate because of engaging in risky behaviors, whether physically or financially.
Thank you. Yes, I'm sorry, I didn't mean to cut you off, Carolyn. Go
I
ahead.
just wanted to add that when you work with people whose loved ones suffer from serious mental illness, substance use disorder, autism spectrum, physical illnesses, which can manifest with psychiatric symptoms, there is a need for guardianship, although it may not get you what you need. They're usually younger adults in my particular practice, but not always. And sometimes as Anita, they're sort of in the middle of the younger population and then the aging population. In this case, sadly, Anita has no family, only a friend, as Sabrina said, is too often the case involving guardianship cases. Whether it's a family, a friend, a neighbor, it's important to talk to those clients or families about, as I call it, what guardianship buys you and what it doesn't. We talk about guardianship can buy you access to medical information, gets you around the confidentiality statutes, find the person a place to live, decide if they can drive a car or travel. Especially in the mental health world, we have many cases where people have access to their driver's license or their passport and can get on the road or get on an airplane, and we end up in situations where now they're out of state. So guardianship could help us if they're in state, but then traveling state to state or across country to country can be very challenging. If a guardianship is not the answer at that moment, we discuss what alternatives might be and what leverage a client may have to direct that individual into treatment, whether it's medication, a mental health warrant, an inpatient evaluation, a possible hospitalization, outpatient program, a residential therapeutic program, psychiatric intervention, orders of protection, and so on. It's the leverage discussion in which mediation can be hugely helpful. Sometimes we, what I call threaten guardianship, we present it to the individual and say, this is an alternative which we may have no choice to entertain, but before we get there, maybe if we all sit down, work with a mediator, work through the issues, whether it's lack of insight, non-compliance, family conflicts, often we can make that connection and avoid having to go all the way to guardianship.
Thank you so much, Carolyn. And we will have time for Q&A when we complete the presentation. So if you want to put any questions you may have into the Q&A box, we will be checking that before the program concludes. And now I'm going to turn it over to Deborah Rosenthal to discuss resolving issues during a guardianship proceeding.
So a guardianship proceeding, there are two main questions. One is whether a guardian is needed. And the second one is if a guardian is needed, who would be the best guardian? So the first prime question is whether a guardian is needed. Now, all of the parties in their council can agree that no guardian is needed. And, you know, I was recently, I'm involved in a case that's ongoing right now where this has actually happened. Everybody has agreed and the petitioner wants to withdraw the petition. And the court is saying, not so fast. We want to hear the testimony, because once something is in front of a judge and the judge says there's somebody at risk here, the judge sometimes wants to know more about what's going on. So if a guardianship is not needed, sometimes the person has the sufficient capacity to execute the healthcare proxy and the power of attorney and wants to do it, and that can avoid the guardianship. Sometimes they have the capacity to sign the healthcare proxy and the power of attorney, but they don't have the wherewithal to actually sign the healthcare proxy and the power of attorney. So then, you know, the court doesn't want a situation where they're hearing the same testimony in a few months because everybody decided to withdraw the guardianship. So the court sometimes takes their own initiative, and that is despite the fact that the petitioner's counsel needs to put on a case by clear and convincing evidence, which is a very high standard. So, you know, they put on their witnesses and they're not able to prove a guardianship, but the judge is still saying, wait a second, I don't think this alleged incapacitated person is really right. I think I need to do something here. In the case that I'm talking about, the alleged incapacitated person happens to be an attorney and he has a law practice. And he may be okay with a lot of other things, but can he really represent his clients? And the judge is very, very concerned that the alleged incapacitated person can't properly represent clients. In my world, which is generally the older people who don't get better, but sometimes I deal with people who do get better. In my world, generally guardianships are indefinite, but there are times when there's a limited guardian or a guardian that is there for a certain time period, and then we check back with the court and see how the person is doing. The guardianship statute says least restrictive means consistent with functional level. So that means that we're really supposed to tailor the guardianship to the person. So it's not like you pull the petition off the shelf and you put in all the powers. I've seen other attorneys do this. But then I look at the powers, I'm like, these powers bear no relation to this person. So you really have to look, if you're going to go for some kind of limited guardianship, in every guardianship, you really need to look and carefully tailor those powers. Sometimes the most sticky issue is who should be the guardian. There are family members and everyone wants to be the guardian, and they're fighting over this. Oftentimes what a judge will do in those circumstances is pick somebody who's not a family member. And that's a particularly good situation where mediation or discussion among the family can be very helpful, because it may be preferable to everybody to have a family member, even if they can't agree on which one. And maybe they can agree that daughter X is the personal needs guardian and daughter Y is the property management guardian. So there are two primary types of guardians, other than temporary guardians and special guardians, and those are personal needs and property management. So a personal needs guardian is the one who makes doctor's appointments, makes sure they're taking medication, makes sure the living arrangements are appropriate, the health is appropriate. And the property management guardian is the one who makes sure that all the bills are paid and that everything is invested appropriately. Any kind of guardian is a fiduciary. So that means that they have to act in the best interests of their ward, the alleged incapacitated person, or the person in need of a guardian. So a person in need of a guardian is someone who has the capacity to consent to the guardianship and does indeed consent. And that person has to testify at the hearing that they consent to the guardianship. So those are some of the issues that come up, and at any one of these stages, it's really helpful to have the family members and the competing interests and the attorneys talk to each other. First of all, that can streamline the hearing if a hearing is necessary, and it can help really narrow the issues as to what is really what's really going on. The guardian's responsibilities are set forth in the order and judgment or in the order. And those responsibilities are ironclad. So if you need additional powers, then you have to ask the court for those additional powers. You can't automatically assume additional powers that are not granted in the original order. And all of that, all the powers, everything can be negotiated, and it is better to negotiate all of these items outside of the court and then come into court with, we've spoken, this is what we think should happen. These are the powers we think should be given, and really have a nice package for the judge. Doesn't always work that the judge will agree to it, but most times the judge will agree to the package that the parties have elected to assume. And so that I highly recommend that the attorneys speak with each other and a guardianship before the hearing, so that as many issues as possible can be resolved and the hearing can be streamlined or avoided entirely. So in Anita's case, there are several issues leading up to the proceeding. The first is this apartment. It's a co-op, and the legal, just because you inherit a co-op, you don't legally have the right to live there. So here she's living in a co-op that the co-op management could force her out of and basically require her to sell. So that issue does have to be dealt with. The issue of, her screaming in the hallways and being disruptive. I have a ward who, long before I became involved in her case, she racked up $100,000 in legal fees with her co-op. And she was being quite disruptive, let's say defecating in the flower pots and things like that were really quite horrific. So, and she's someone who, she's got some mental issues and some declining cognition. So it's a combination of both. So all of these things, it's so much better the earlier you start the discussion if somebody is going down this path to try and resolve it, than waiting until something catastrophic happens where it's going to cost a lot more money to deal with the issues. There are alternatives to a guardianship, and the primary ones are a healthcare proxy, a power of attorney. If the person's young enough, we can also do a supplemental needs trust for their assets and have the trustee manage those assets. But healthcare proxies and powers of attorney, especially powers of attorney, are not the be-all and end-all. There are many guardianships that are initiated because someone had the trust of the alleged incapacitated person at some point, signed, there was a power of attorney giving that person rights, and then they stole everything or stole all kinds of things. And there also are many cases where there are competing powers of attorney. That's a red flag. If the alleged incapacitated person is signing 3 or 4 powers of attorney, naming different people within a year, that shows you that the person is easily swayed and really doesn't really understand what they're doing, and not able to really sign those powers of attorney because they're all, you can't keep on changing your mind on that issue. The family should talk about what kind of resources are available and who should be providing support. Those, some family members are more able to help than others. But when you have an ill family member, it puts a strain on everybody. And people get short-tempered, they think they're right. And if you're going to try and mediate this, you have to listen to every side and try and come to a resolution that acknowledges everybody's position and helps them reach a resolution that's really best for the alleged incapacitated person. There are people who get involved in guardianships who think it's all about them, you know, family members, and there's only one person the guardianship is about. It's that alleged incapacitated person. That's who the court cares about, and that's who the whole hearing is about. So that's where everybody's focus should be, is what's in the best interests of the alleged incapacitated person. Sometimes it's helpful to, you know, depending on what your role is, the court evaluator sometimes is in a good position because that person talks to every family member, and that person, you know, isn't aligned to one person's viewpoint, whereas the petitioner's counsel, the counsel for the alleged incapacitated person, the temporary guardian, the cross petitioner, they all have a particular viewpoint that they're advocating for. Whereas the court evaluator's job is to report to the court, talk to everybody, and reach a decision as to whether or not, an opinion as to whether or not a guardianship is necessary. So sometimes it's not a bad idea to lean on the court evaluator to help resolve the guardianship and help the parties really realize what their issues are.
And just so people understand, the court evaluator is going to be appointed by the guardianship judge when the petition is brought. Correct?
Yes.
Yeah.
The court evaluator and the court, one of the primary roles of the court evaluator is meet with the alleged incapacitated person. And if no counsel has been appointed yet in the petition, in the order to show cause, then the first thing the guardian needs to do is, the court evaluator needs to do, is to ask the alleged incapacitated person, do you agree with the guardianship? Do you want counsel? And if either of those questions, if you agree with the guardianship is no, or you say, do you want counsel is yes, the interview stops, and the court evaluator must notify the judge that the person needs counsel appointed.
Thank you. Thank you so much, Deb. I think I'm going to turn it back over to Sabrina now to discuss resolving issues after a guardian is appointed. And again, if you have questions about any of the content you've been listening to, use the Q&A feature in your on your screen to post the questions, and we're going to get to them at the end.
Thank you,
And
Marcy.
yeah.
So for those of you who don't do guardianship work or aren't familiar with guardianship cases, I think you can see at this point that there are many issues that come up. And if you haven't heard it already, there's a lot of collaboration that goes on. There is a lot of discussion among the parties before the case ever gets to court. The court evaluator, as we mentioned, is interviewing people, is reviewing documents, is calling petitioner's counsel to say what's going on. Are you sure you need 20 powers? Why do you need 20 powers? Why don't you just need 10 powers? If you're representing a child of an alleged incapacitated person and you want to oppose a guardianship or even appear in the case, you, through your attorney, can be in touch with the court evaluator. There's a lot of discussion that goes on before this case ever makes its way in front of a judge. So I just want to make that clear. After a guardian is appointed, because this is a person's life, it's an ongoing living being, there are many issues that can come up post-guardianship. And I always tell new attorneys who are doing guardianship work to make sure that you stay in touch with the court. There are certain issues that require court approval and court intervention. Among those are relocating a ward. A permanent change of address in New York must be approved by the court, and you must file a petition to do that. So if your client is permanently moving from their apartment to a skilled nursing facility, You cannot do that without a petition. You could do temporary move, you could do a move for physical therapy, but you cannot permanently change the address of your ward without a petition and approval of the court. Estate planning. Can a person do a will if they are in a guardianship? They can, with permission of the court. The judge has to believe that the person is lucid enough to do that document. And in order to do that, you have to get it in front of the court. In the statute, it requires any gifting of a person's assets must be approved by the court. So let's say you have a moneyed a ward who has money, and you believe it would be in her best interest to make gifts to reduce her taxable estate, let's say, and that sometimes happens. That's a petition in front of the court with a hearing, and the court makes a decision. So that's not something that a guardian can do on his or her own. Let's say that you're involved, and this happens a lot in end-of-life decision-making. The court will definitely put powers in your order when you're appointed relating to this, and there's statutory authority for different types of end-of-life decision-making through the public health law. But when I am involved in a case and a person is near death, approaching death, I always let the judge know. Always tell them so they're not surprised, and particularly if you think there's going to be any conflicts that come up with regards to decision making. If you think there's a family member who's going to object to one thing or another thing, you owe it to the judge to let them know that in advance. So I always try to keep them involved of major issues that are coming up. These are only a few of the issues. And again, going back to our theme, which is dispute resolution, if I know, let's say I'm a guardian, and I know that there are people involved in the case who are going to object or else just have an interest in something that I'm going to do. Let's say I'm going to move a person. I'm going to reach out to them. Again, we try to be as collaborative as possible. Let's say it's a child, explaining to them why this needs to happen, trying to get them on board, answering any questions, bringing the child, an adult child, to the facility, letting them see the facility, letting them feel comfortable where their parent or loved one is going to be. This is a part of something that we should do every single day. And if you don't, you're going to run into issues. Is it always possible? No. Sometimes you cannot do it. Sometimes you can't bring people in. But in every situation that we can bring them in, we try to do it. And if it's an issue, for example, about estate planning and gifting, most of the time the court will appoint or reappoint counsel for that person because they want to make sure that your ward has independent representation. So if I'm making a petition to gift away $1 million, right? The court almost always will appoint counsel for my ward, independent counsel, to have another set of eyes on that. So that's another person that you would be speaking to. That's another person that you would be collaborating with to reach the result that you believe is best for your ward. So you can see it is a living, like I said, it's a living, breathing person. It's their life, and you're doing what you can do to make their life better, to make their life work. And depending on what is happening with them, it can get very complicated. And I think that's probably a good summary of things that could happen. There's, as many things as there are people that can happen, but those are some of the major ones.
Thank you, Sabrina. And so our slide talks about interpersonal conflicts with family members. Not every dispute rises to a legal claim. And as you've mentioned over and over again, trying to resolve issues outside of court and scheduling a conference with the court if things cannot be resolved. You might want to...
Marcy, could I just ask you for a second to bring this back to Anita?
Sure.
Because this is what you do. You could see a mediation, right, between Anita and her building and Anita and her friend.
Right,
or people in the building, let's say her neighbors, you could see some type of group discussion about that, right? Before they go to court.
absolutely. But just sticking with what's, we're going to come back to Anita because I have quite a few questions to ask the three of you about Anita, but just a little wrap up about what happens with the changing needs of the ward. What do you do when the ward's needs change, and how do you get a change to the powers?
So let's say, I mentioned a move. So let's say a person's in their apartment and they can walk and they can move and they can do everything on their own with help, or with a lot of things with help. And let's say they have some traumatic injury or illness that requires them to move to a skilled nursing facility. Okay, that is a change of address, which requires, as I said, requires permission of the court on petition. Sometimes we talked about keeping the powers limited. Deborah talked about limited powers. You might end up with a handful of powers, and later those powers might change. I could give you examples. Let's say that the person has a daughter and the judge gave the daughter end of life decision making and said, if something happens, it's the daughter who makes the decision. If the daughter, for whatever reason, can't do that, let's say the daughter passes away, predeceases her mom, somebody has to have those powers. The court may increase your powers to include that as a power. You might end up with a power in the beginning that you don't need later. You could have a financial power and somebody could get better. Sometimes the guardianships go away. I've had several. It's usually younger people. But I did get appointed one time for a man who had a traumatic brain injury and had to settle a case, his litigation, and he couldn't settle it. And the court appointed me with specific powers in a special guardian role to settle the case. So I worked with him, I worked with his PI attorneys, and we settled the case to his satisfaction, but he just couldn't do it on his own. After that, the guardianship went away. So sometimes the powers will just go away. Again, it's with an order from the court. In terms of working with people, we have a little blip that says you can sometimes do a stipulation. Depends on what the issue is, but as Deborah said, to bring in as many people as possible, put together a proposal for the court and then present it to the court is always helpful. And I think the courts actually do appreciate that.
Thank you again. And so we're just showing some resources available in the community outside of anything that a particular court program offers, although there is a reference to the family court program. And that you'll all be getting the slides. And I think I can end the PowerPoint and take us to some questions, Q&A. Let's see if I can figure out how to do this.
Marcy, before that, I just wanted to go back and talk about the possibility of avoiding guardianships, not having to get there in the first place, and
Sure.
mediation.
Go ahead, Carolyn.
Mediation actually can send a very supportive message, and it can give a path for family members to feel heard, understanding what needs to be done and accomplished, and sometimes can even avoid getting into guardianship land in the first place, although not always. It also keeps at bay a family's fear that they're going to be cut out, they're going to be ignored, that they're not going to continue to be able to participate in what is going on with their loved one. Maybe it's decided that it'll be a third-party guardian, as has been talked about, or the court will advocate for other powers, or there are powers they hadn't thought of. So it's a way, again, of being supportive and bringing people together to talk about the reality of needing a guardian or not. And the other thing that it can do that we found is it can bring in alternative support systems, geriatric care managers, case managers, psychiatrists, therapists, other people who may be able to work with the mediator, with the family, to bring them all together in order not to have to go the whole way into a full-blown guardianship, or can narrow the powers that are needed, as has been talked about, or can resolve powers or resolve issues that we may not need to litigate somewhere down the road. So it takes some of the adversarial bite out of what these proceedings could be and makes it much more collaborative.
Thank you. So a question for you, Sabrina, back to Anita. Who might bring the petition for a guardianship in Anita's situation? And at what point do you think it would become inevitable that a petition would be brought in her situation?
Well, it's interesting. I was thinking about two different ways. So first of all, of course, the building can bring it. It's any person who is interested in the person's well-being. And in this case, they have an interest in her being okay, but they also have an interest in her, in protecting other people in the building. So they have two sort of interests in it. They also, I've seen this happen, and it actually happens quite common. They go into housing court. Let's say they file a petition to evict her because, as Deborah said, she's not a true owner of this property. And if they get fed up with her, they could go into housing court, move to evict her. If she either shows up and is inappropriate and is clear to the judge she can't understand what's going on, or she has a guardian ad litem appointed, which sometimes happens in housing court, and that guardian ad litem advises the court that she's not capable of participating in this case, I have seen judges direct the petitioner to file for guardianship. So it could be on the initiative of the building, or they could be in housing court, and the housing court judge could direct them to do it in order to protect her interests, especially if they feel like she's not capable of participating in the case.
Thank you. And Carolyn, in her situation with the problem with her taking her or refusing to take her meds, what would happen with her situation? Is there a way to negotiate, encourage? Like, what do you do with a client who's off their meds?
That's a very big problem and challenge. It's what I alluded to earlier, which is what a guardianship buys you or doesn't. So unfortunately, in my view, in New York, a guardian can't force someone into treatment or keep them in treatment or override a refusal, and can't involuntarily commit someone. Now, there are other sections of the mental hygiene law that governs that or compensates for that, but that's only through an involuntary hospital commitment. So if you're not going to go that route, then the issue before you is, what leverage do you bring to bear on the person to try and move them or cajole them into becoming more compliant with their treatment? Sometimes it's money, sometimes it's threat of guardianship, sometimes it's housing. It could be a variety of things, the ability to drive a car or have a car. It really depends on the situation, but it's very challenging because, again, our only involuntary option in the system is a hospital. And after that, everything becomes a voluntary and by agreement.
Thank you. I think Don wants to share the code with everyone who wants CLE. You're muted, Don. You're muted.
Yep. So I've got the code for all of us. So I just posted a link in the chat. So that is our CLE code registration and verification form. So the code for this session is emerge. Spelled just as it is sounds. EMERGE. That is it.
Thank you.
Yep.
Can you check the Q&A box and see if there are any outstanding questions for us, Don?
I just answered a handful too.
Oh, one-on-one?
Yeah, I just wrote back.
Do you want to share any of the questions that you addressed, Sabrina?
Yeah, sure. They were, one was, can there be more than one guardian? And yes, there can. There's sometimes co-guardians. They can have the same powers, or as Deborah said, you could have a property guardian who has a certain set of powers and then a personal guardian who has personal needs powers. There was another question, which was, are only attorneys guardians? And no, that is not the case. Family members can be guardians. And also in New York, we have a lot of social workers who also are guardians. And then the other question was, what type of training do we do? And I put in there that I answered that we have to have training before we can be appointed. There's a mandatory training. We also have, through the Women's Bar, the Guardianship Diversity Initiative, which does ongoing training and mentoring for anyone who's doing guardianship or court appointments in guardianship. And whenever I do my CLE, I try to gear it to guardianship just because there's so much to learn. But in a guardianship case, it could be anything. You could be dealing with estate planning, you could be dealing with real estate issues, you could be dealing with personal injury issues, you could be dealing with Medicaid, you could be dealing with issues like Anita has, which deal with her landlord. I mean, it's kind of a Pandora's box of issues. And so, the CLE that we have in New York every two years is good training, because you can pick something that actually affects a case that you're involved in.
Thank you. And before we wrap up, we have a few more minutes. Deborah, you are muted, but would you like to address the hoarding situation, maybe as it applies to Anita or some clients that you've dealt with in person?
Okay, so this is a very common situation, and oftentimes it's the building that, whether it's a co-op, a condo, or a rental, the building gets involved, either because the neighbors see a problem, or somebody from the building goes into the apartment and sees that there's a fire risk there. And, oftentimes the building will call Adult Protective Services and have Adult Protective Services make a visit. They have the right to come in to visit unannounced. The Adult Protective Services also has psychiatrists who come and visit. When I'm counsel to an alleged incapacitated person and there's a psychiatrist who comes in and then testifies at a hearing, I have a problem with that, but usually the judges will allow that testimony in. An alleged incapacitated person cannot give their HIPAA rights to anyone. Even their attorney can't exercise their HIPAA rights. Those HIPAA rights are that person's individual rights. Sometimes these cases bring issues like that. Adult Protective Services often is involved in those cases, and it's not just a case where the person is a danger to themselves, because with the hoarding situation, it really becomes a danger to the whole building. And those are issues that a court evaluator needs to answer. Is the person a danger to themselves or to others? Sometimes you can mediate that, but it's very, very, very difficult. Somebody who has a need for that stuff, it's very hard to convince them that somebody can come in and clean it up. Sometimes those people wind up in a hospital, and then at that point, a family member or somebody comes in with permission from the court and cleans out the premises. But I find these cases extremely difficult because there's a mental thing that's going on, that the person needs all that stuff and can't stop. And even if you clean it up, sometimes it comes back. Just like Anita, has a lot of issues, including this one, that are common. This is a very, very common one. And if someone has the problem in a house, people don't know it. But if you're in a building, other people know it. I did have a situation recently where a client invited me to her home to do estate planning and to work on her husband's estate. And when I got to the home, I realized she had a problem.
Thank you.
And so, you know, I said, would you like somebody to come and help you? And that she does have somebody now helping her clean the home, but it was very frightening to her initially. And I do think that the reason why she let me into her house is because that was a cry for help.
Thank you. I just want to briefly mention in the few minutes that we have left, the issue of capacity. And the issue of capacity in a mediation is different from what capacity might be in the actual guardianship proceeding. So it might be a very black and white decision in the guardianship proceeding about whether the alleged incapacitated person has the capacity to handle the financial affairs and their personal care. But if you can get an AIP, an alleged incapacitated person, to a mediation and sit them down at the table with the interested family members, as long as they can meaningfully understand what the mediation is about and what the issues are, you don't have to pass a legal bar for capacity that you might be a problem for the client, the alleged incapacitated person, at the actual guardianship proceeding. So I don't know if any of you want to make a comment on the issue of capacity before we wrap up. We're just about done.
I mean, capacity can wax and wane. You can have it in some areas and not in others, sometimes and not in others. It's also very subject specific, so that if somebody understands what they have in terms of assets, that may show they have some capacity, but they can't pay bills or figure out how to go online to pay bills or get help for that. So capacity is kind of a moving target, and it's also very specific to the individual. What can they do? What can't they do? There are ethical rules for lawyers to have to make a judgment on whether that individual has capacity to execute documents, to participate in a legal proceeding, and so on. So I think it's helpful to know from the mediation standpoint what that capacity really is. It's a much higher standard and much more specific in a guardianship proceeding.
Thank you. Thank you, Carolyn, specifically for that. And thank you, Sabrina and Deborah and Carolyn, for sharing your expertise here today. Don, I think we're ready to conclude, but if there are any details, administrative details you need to address before we close?
Yep, so I will just give the CLE code one more time for those that missed it. So it is emerge, EMERGE. We have one more closing session with Allison. She is the chair of our conference committee, so that should be coming up shortly. So I will end the webinar. Everyone will be booted back to the lobby and you can access the closing from there.
Thank you again.
All right,
Thank
thanks.
you.
Thank
Yep.
you all.
Mhm.